The debt validation letter, law, strategy, and misconceptions. One. The myth of the secret letter. Can one letter erase debt? Not exactly. But here's the truth. Under the Fair Debt Collection Practices Act, FDCPA, 15 U.S.C. Section 1692 grams, consumers have the right to demand proof of a debt. If a third-party collector cannot provide documentation, they must cease collection. This does not cancel the debt, it neutralizes the collector's claim until validation occurs. Footnote. The FDCPA requires debt collectors to validate debts on request. Failure stops collection. 2. Who this applies to. The validation process only applies to third-party debt collectors, collection agencies, collection law firms, or debt buyers. It does not apply to original creditors like your bank or credit card issuer. If Capital One is pursuing you directly, the letter won't work. But if ABC Collections is knocking at your door, the law kicks in. Footnote. Validation rights are triggered only against third-party debt collectors. 3. The chain of title problem. When debts are sold, they often travel in bulk, thousands of accounts at once, for pennies on the dollar. The buyer rarely receives the original signed agreements. Without that chain of title, they cannot legally prove ownership. Imagine your neighbor claiming you owe him $1,000 because he bought your IOU from a bank. Unless he shows paperwork linking him to you, he has no standing. Footnote. Most collection agencies lack proper documentation proving debt ownership. 4. How the letter works. Send a debt validation letter within 30 days of first contact. Use certified, trackable mail. Do not include personal IDs or legal signatures. Once received, the collector must stop collection until they produce proper documentation, original contracts, itemized statements, and proof of assignment. If they cannot legally report or sue on that debt. Footnote. A valid debt validation letter halts collection until proof is provided. 5. Common mistakes. Collectors often respond with invoices or generic statements. These are not contracts. Courts require actual evidence tying you to the debt. If sued, consumers can file a motion to dismiss for lack of standing, arguing the collector cannot prove ownership. The burden of proof lies on the plaintiff, not the defendant. Footnote. Generic statements or invoices are not sufficient legal proof of debt. 6. Strategy beyond the letter. If validation is ignored, the next step is to dispute the trade line with Experian, Equifax, and TransUnion. Provide the certified mail receipt as evidence. If the bureaus leave it on your report, escalate with a method of verification, MOV, request. This forces them to explain how they verified the debt. Persistent use of this process often results in deletion. Footnote. Escalation with credit bureaus increases pressure for deletion of unverifiable debt. 7. The limits of the law. Debt validation is a shield, not a sword. It does not erase legally valid debts. It only stops collectors who cannot prove ownership. Lawsuits may still occur, and consumers must appear in court. Ignoring summonses guarantees default judgments. Showing up with the law on your side shifts the balance. Footnote. Validation creates defenses but does not extinguish genuine debts. 8. Final takeaway. The so-called secret letter is simply a debt validation request. It is powerful, but not magical. Used properly, it can eliminate illegitimate collection attempts and protect credit reports. Used carelessly, it breeds false hope. Debt management requires persistence, strategy, and respect for the law. Footnote. The FDCPA provides leverage, not loopholes. Persistence and documentation are key.